Case number 2172, Foster Garner versus Manziel. All parties, please come forward.
Jamar Foster and Sean Garner are suing record producer Livin Manziel for event costs after Livin canceled their Halloween party.
Who's Mr. Garner? Mr. Foster?
Right.
Are you going to be speaking? You're standing in the speaking spot.
Yes, ma'am.
Okay, great. According to what I read, the defendant rents a music studio. Is that correct?
I rent a facility in which I own a music studio.
You rent in someone else's building?
Yes.
And you're recording people. During the course of your business, you decided to enter into an agreement with the defendant to use that recording studio, which she rents from that space, which she rents from a landlord.
May I correct you, please, Your Honor?
Yes.
She actually is a facility that has multiple units in it. She runs a studio, and then there's other event space inside of that same facility.
Okay, give me an idea of how large the space is.
I believe we were quoted something like 5,800 square feet.
And so you have a music studio, and around it is other open space.
Yes.
You decided to go into some sort of a business with her. You wanted to run events.
Yes, ma'am.
Social events, nothing to do with the music studio.
Absolutely not.
Is that correct?
Yes.
And according to you, you gave her $6,000,
Yes, ma'am.
sort of front money, to start using that space.
Yes, ma'am.
Subsequent to giving her the money, according to you, there were restrictions put on the space, on the number of people you could have, the kind of parties you could have, etc.
No, absolutely. I apologize.
Well, you have to pay attention,
Okay.
sir, because what I'm suggesting is really in your favor.
Oh, okay. Let me. Okay.
So, is really in your favor, so you have to think.
Okay.
Subsequent to giving her, that means after giving her the money, restrictions were put on the kinds of events and the number of people you could have in the space. Is that true or not true?
That is absolutely true.
No, that's not.
I'll get to you in a second.
Okay.
And you want your $6,000 back.
Yes, ma'am. And
That's what it's about. The defendant does not deny that you gave her $6,000. And then I'm going to hear what her defense is. So I want you to tell me, when, for the first time, did you have a discussion with the defendant about going into this business venture where you would front the money and whatever events you would have there, you would reap the benefit, the financial benefit from that? When did you have that discussion with her?
Okay, so we met Livin at the end of August of 2022. We actually signed the agreement pretty fast. We signed the contract agreement on September 1st.
May I see the agreement?
Yes, ma'am.
There was no agreement signed, so I don't know how it could be signed.
She keeps arguing that.
Just a second. Could you be quiet?
Yes, ma'am.
So in your hands,
Shh.
that's the studio that she runs?
Sarah, you have to sort of explain it, because I don't see signatures. You know, I'm used to looking at contracts where people sign things. But I know you can sign things by DocuSign now. Your signature isn't on here.
Yes, ma'am.
And,
That looks like a signature from a DocuSign or some sort of online.
okay, is that you?
This was a proposal that I did. I do not even own it yet as a DBA.
Just a second. It's getting better. Don't say anything. This is your proposal. Now I'm going to read it.
Okay.
And your masterpiece management.
Yes, ma'am.
Okay, well, so this is sort of easy. You prepared this proposal. Speak.
Yes, after.
Just a
this-
second.
okay.
You
Yes, ma'am.
prepared this proposal.
Yes, ma'am.
And as a result of this proposal, you received and deposited $6,000.
Yes.
Yes, well, then you have a binding contract, okay?
Okay.
So that's what I'm telling you. You have a binding contract. And there is nothing in this contract that limits the kinds of events or the number of people or anything else with regard to this space. All it says is business activities, event planning, and event rentals. Nothing else. And this is your proposal, so the terms of it are construed if there's any material question, since you prepared the agreement, which became a contract once you accepted their $6,000. I view the terms of the agreement most harshly against you because you prepared the document. And it says this agreement cannot be amended without the written consent of all parties.
Yes.
Yes. So signed the agreement, you got the money, and then at some point, according to them and according to you, you made certain limitations on the kinds of events, the numbers of people, etc.
That is
Now that happened according to you because you do not own that space, you rent that space, and there was a problem with the first party that they threw.
correct.
Come on, we're not talking about Gone with the Wind here. We're not talking about a 6-volume masterpiece. We're talking about a yes or a no. Okay, there was a party that got out of hand.
Yes, ma'am.
Okay, and after that party that got out of hand, too many people or whatever it was, your landlord complained.
Yes.
Okay, and it was after that that you told your 2 partners that
We are not partners.
Yeah, according to this you are.
We didn't finalize the agreement.
This is a finalized agreement, madam. I just said to you, I want you to pay attention. This is your proposal. Based upon this proposal, they gave you $6,000, which you deposited into your bank account. That means a contract was created. That's the agreement. I'm telling you. That's the law.
Okay.
You prepared the proposal. You signed it. They said, okay. And they fulfilled their part of the agreement by giving you $6,000, which you accepted. Got it? Got it? And you can't, according to the agreement that you prepared, modify this agreement any other way than a written contract signed by both parties. You can't change the rules. Did you know that this was rented space?
We didn't have all of the details about the place.
Well, see, next time you should know what you're dealing with, whether she's the owner or whether she's not the owner, whether she's a renter, whether she has the ability to rent out to sublease for events. I mean, all of these things, before you give somebody $6,000, you should know that. Okay. And you had one event at the space?
No, we actually didn't get an opportunity to throw any events at the space at all. The event that you were speaking of, she had partnered with another group of promoters and individuals to throw that party. So you
didn't have anything to do with that? What was it, a Halloween party or something? It was a Halloween party. But that wasn't with you?
No, that wasn't.
Is that correct?
He was part of the event.
Is that correct, that
No.
it was with other people?
Yes, it was correct. It was with other people. They were just associated with the event. They worked at the event. And
I don't care whether they worked at the event. You received money from other people for an event.
Yes, ma'am.
Well,
Yes,
let's be clear. And after that event, you imposed additional restrictions on the use of the space.
No, Your
Just hold on a second.
They knew about the event.
Hold on. They can't tell me what they knew. This is your contract.
They called a fire marshal.
My landlord contacted me that the neighbors were complaining. People were parking on their lawns 90 minutes into the party, but it was not their party. Somebody else paid you for it. The next party they wanted to throw involved minors, and I told them absolutely not.
Yes, ma'am.
I just made it clear what types of events would be approved. Well, you can't do that. I'm just telling you, you can't do that.
Ma'am, I'm not allowed to throw events that have out drugs for children.
You have to understand something. You can do whatever you want as long as you put it in a contract. You prepared the contract. This contract is silent as to any restrictions on the space for events. So you have to give them their $6,000 back because they didn't have an event. They got nothing of value for their $6,000.
Correction. They were managing an artist whenever I met them that they were responsible for paying. So I'm countersuing them for $1,050.
Just a second.
Okay.
$6,000 they get back.
Okay.
Easy? That's a contract case. Now, you have a counterclaim, and your counterclaim is for $1,000 because you say they owe you that for a rental that they did for an artist that they manage.
I provided my services as a recording artist and a music producer for their artists. I provided them with 2 exclusive beats.
Well, show me the contract with them.
I have.
Just show me the contract with them.
There was no contract.
Judgment for the plaintiff in the amount of $6,000. Counterclaim dismissed. We're done. Thank you very
Court
much.
is adjourned.
I was just trying to have a proposal, not a finalized agreement.
Well, I appreciate us getting some type of justice out of the situation.
They came in wanting to do multiple things, and I was excited for my small business.
We tried as much as we could to help out and make sure that we increase the revenue streams inside of that business.
They're actually going to be hosting hookahs with children at your event in your space. I'm not comfortable with that.
To ever associate us with any type of drug use or abuse, especially involving children, that was just an inaccurate claim.
I think it's better just to part ways.
Move over to bigger and better things.
I was going to tell you I had the invitation, per se, for the event for Halloween that they had put together. So they put a lot of time and effort into planning the party. It seemed very legitimate. There was notes about security. There was notes about no alcohol, food and drink will be provided. So I could tell that they had put in a lot of effort to hosting this event. And although it wasn't a malicious breach on the defendant's part, I understand she hosted a party that had nothing to do with the plaintiffs that she got into a little bit of hot water. So to be cautious, she was letting them know, hey, I can't host these types of events with a lot of people. It makes the street too crowded, whatever the reason. However, I disagree with you because I would have given them the full $10,000 that they were asking because although not a malicious breach, and I understand her concern after having the incident with the previous party, but that's not their fault.
You believe that the difference between the cost of one venue to another should be ascribed to them. It's interesting, but the $6,000 was to cover a lot of events. This is one event. So
I see your point now that you put it that way.
Maybe,
I just think if you were going to make them whole, they should receive their expectant damages as well, or whatever they relied on based on the contract.
I accept your opinion
Sure.
and perspective.
At the end, Judy told her granddaughter that she accepted her opinion, which just melts my heart. You could see the bond and the relationship they have, which makes sense to me a lot. Before my late grandparent passed, my grandfather used to love me a lot. So I have a feel of what that relationship feels like. So the whole case is about an event. They were suing for an event. And I like the opinion that the granddaughter gave. She said if it was her, she would have giving them the whole $10,000 they were suing for. And her reasons was that she went through the Halloween party, she saw the graphics, and they said there's no alcohol, no minors and all of that. They provide the food and the drinks for the party, and it looked very legit. And then for them to go and have to get another space for the Halloween party, it cost them a lot. So she believed that Judge Judy should have awarded them for damages too and all of that. But at the end of the case, Judge Judy didn't award them any damages. She only refunded them back their $6,000 they paid for the place. So the whole case is actually about an event place which the defendant do not own, but the plaintiff was not aware that she didn't own the place. They thought she was the owner of the place. They wanted to throw a party in the place and all of that, and it affected, at the end of the day, they couldn't throw a party because there was a party prior, and the landlord, that's the main owner of the building, complained that the neighbors have been complaining that people were parking on their lawns. There was a lot of cars on the street and all of that. And it made that she had to amend the contract they already had, even though the defendant was denying that there was no contract at all. But then, according to the proof provided by the plaintiff, Judge Judy could see that they had a contract earlier before the party. But according to the defendant, she said it was a proposal she prepared for them between she and the plaintiffs, so that they could go through it. They've not finalized on the proposal she prepared. But then, looking at the thing and then giving her granddaughter to go through it, she found out that it was a signed contract online. They might not have physically signed it, but there was an agreement, and they fulfilled their own part of the agreement, which is paying the $6,000 for the place, and which they did pay. And at the end of the day, they didn't use the space for the event they are planning. She was trying to implicate them, saying that the prior event, they were involved in the prior event. But when Judge Judy pressed further, she agreed that it wasn't that they were part of the prior event. They only volunteered or they worked in the prior event, which made that somebody else paid for the event center, and then they only worked with the people. So they were not actually the ones that threw a party there. Somebody else threw a party. So with the burden of proof on her, she couldn't provide any proof, even on her counterclaim, which she said that they had an artist. She produced 2 beats for the artist, and they didn't pay for it. So she was countersuing for $1,000, which at the end of the day, Judge Judy didn't give her. So I like the fact that she didn't give her anything. But the case ended with Judge Judy awarding the plaintiffs $6,000 refund. That's the return of their initial deposit for the event place. But I wish that she paid them for damages, because at the end of the day, they had to go and rent another place and use the other place for the party, which might have affected their business, even though there was no complaint that it affected their business. I believe that you enjoyed this video. Please don't forget to like, share, subscribe, and leave a comment below as I bring you more content from Judge Judy. Thank you. See you next time.